So for those of you who are just jumping in, thanks for joining us. We're gonna give people a few more minutes. We still have a few minutes before noon, so we'll give people a chance to join in. All right, well, hi everyone who's joined us. We're gonna let people join as we're getting started. I know we have a lot to get through today. So again, thanks for joining us for our employment law through times of change presentation. I'm Leora Kirk from KLA Consulting, and we're so excited to have with us today Katy Rand from Pierce. She's a partner at Pierce Atwood, and she's going to help guide us through all of these changes that are coming at us so quickly. I know there's a lot of anxiety and uncertainty, and so we're hoping to be able to help alleviate some of that today, um, and just help everybody feel like they're better prepared. Some quick housekeeping notes for everybody. The presentation is being recorded. We will upload it to the KMA website just as soon as we can. The slides will be shared. So like I mentioned, we have a lot of information to get through. We're going to be moving pretty quickly. So we wanted everybody to have this information so you can review it at your own pace too. The program is eligible for SHRM credits. So if you need those, you'll get a follow-up email with instructions on how to get those. And then lastly, we are going to leave our Q&A feature open. We have a lot of participants today. We might not be able to get to all of your questions, but please put them into the Q&A. We will do our very best. If some come up and there's a lot of the same questions or they're really relevant, we'll do our best, or we'll give them to Katy so she can address those. Just a quick disclaimer too before we go in that this presentation is for informational purposes. It's not legal advice. If you need legal advice, please do consult with your attorney. Before we get started, really started this time, we wanted to take a minute to do this quick survey with you all. So for those of you who are familiar or not, you can take your phone and just scan it to the QR code on your screen. It's going to take you to this little short survey. This will update for us in real time. So if you wanted to do that, if you don't have your phone for a QR code, you can copy the link into your browser and we can take a look at these together. So of the following changes to employment policies, which do you think could impact your business the most? And as you log in, you'll see all these options listed for you. So we're going to let people have a minute to catch up to us. We have one response. Let's see how quick you all are at this lunchtime hour.
That's cool. I've never seen this tool before. That's really interesting.
Yeah, it's just giving everybody a chance because it takes a minute to update. I feel like Maine paid family medical leave is still high on everybody's list of top of mind.
Sorry to disappoint. We're going to spend very little time on that today.
We can come back to this too at the end as it updates. The second question was, has your organization taken any steps to adapt to recent changes in policies? So everybody's, this is sort of what I was feeling like. We're all kind of evaluating, or most companies are still evaluating. We're not really sure, like, out of everything that's coming at us so quick, like what's the top priority? And so, yeah, really kind of taking everything in. We can come back at the end of the presentation if we have a minute and see where these shifted. I'm just going to go back to the first. Still, Maine paid family medical leave. Very interesting. All right. Well, with that, we're gonna jump in because, like we said, we have a lot on our agenda today. This is a quick overview of what we're going to cover today. And yeah, before we got started, we thought it would be incredibly valuable to do a quick civics refresher. So with that, I'm going to pass it to our expert, Katy.
All right, and apologies for people for whom this is really elementary, but I'm talking to a lot of people for whom it isn't, and what's coming out of Washington, really to understand the context of it, what it means and what it doesn't, it's really important to understand sort of what executive orders are and how laws are made. I'll tell you in a minute, they're not laws. So refresher, Congress, passes laws, enacts statutes. Judges say what the law is, what laws mean, fill in the gaps in statutes, adjudicate disputes, and the executive branch, that the president runs, enforces and implements the law. Those are their three roles. Go ahead. What's complicating matters and has really for a long time are administrative agency regulations and guidance and interpretations. And so the administrative agencies, the ones most relevant to the employment context would be, DOL, NLRB, EEOC. Those are part of the executive branch. And so in, some more than others, personnel changes with each new administration, and certainly the way they interpret the law changes with each administration, at least if there are differences in policies. Administrative agencies do sort of make laws. They make rules and regulations that in some ways are more relevant to kind of the day-to-day employment law HR work than the statute itself. So for example, the FMLA, just about everything we know about the FMLA comes from a set of regulations. The statute, I can't remember the last time I looked at the statute, but I look at the regulations all the time. And the EEOC will issue, guidance on things, all kinds of things, harassment, accommodations, really helpful. The agencies also adjudicate disputes, some more than others. I would say increasingly, while as it has been increasingly difficult for things to get done in Congress, I think agencies have stepped in even more to fill in that gap. But it's really hard on employers when the rules change every 4 or 8 years. And so, we've had whiplash with things like the independent contractor rule. The NLRB is most notorious for flipping, and what does this general counsel say is okay around social media policies, and that's changing all the time. For a very long time, the law has been that the courts would defer if an agency was interpreting an ambiguous statute, right? So the statute didn't really answer the question, and the agency had adopted a rule that filled in that gap. The courts would defer to that interpretation, and that's why rules have been so important, especially in the employment law realm. Almost a year ago, the Supreme Court overturned the case that said that courts should defer to agencies' interpretations. And so, now what they said basically is it's the court's role to decide what the law is. And so unless a statute expressly gives an agency authority, and some do, sometimes right in the statute, it will say the Department of Labor will pass rules XYZ. But unless that exists, that courts are responsible for determining what statutes mean. And we're only just beginning to see what that means, right? There are regulations being challenged left and right. And the Supreme Court can't hear all of those cases. So the courts of appeal and the lower federal courts are going to be deciding those cases. And there are probably going to be some jurisdictions where where the rules are still respected and given deference, and others where they're not. So we're going to have, that's just a preview that those of you with multi-state operations, unfortunately, it's not going to get easier it's going to get worse before it gets better, the inconsistency. Go ahead. So that was just a backdrop for executive orders, because it's really easy. They're official. They look official. You know, they were signed with a large pen, and they feel like laws, but they're not laws. And that doesn't mean they're not important, or that they're not something we should pay attention to. I just want to be clear that they haven't changed the law. What they've done, what the executive orders do, is direct the agencies to take certain actions, to interpret the law in certain ways, to implement the law in certain ways. And, you know, you've seen many of the executive orders that we've seen this year so far are being challenged. You know, some have been enjoined. We'll talk about one in a minute, or parts of some. Other ways that the executive orders could sort of not come to be, or could come to be law, is Congress. If they you know can come together and pass legislation, either rejecting, right, amending a law to make it clear that the executive order isn't consistent with the law, or codifying the executive order and putting that interpretation into the law. They could do that. I think we won't see a lot of that. Courts, you know, can hold that these executive orders are unconstitutional. And then obviously a future president, as we've seen, can rescind or amend executive orders. I'm only going to talk about two of the executive orders. There are many more, but these two are the ones that I think our clients are most concerned about. And so the first one, this ending illegal discrimination and restoring merit-based opportunity, relevant to employers. It has some other provisions that I'm not going to talk about, but it rescinds the prior executive order that required federal contractors to develop affirmative action plans, at least concerning women and minorities, or you know, the categories other than disabilities and veterans. And so the affirmative action planning process is changing. That raises questions about whether employers should still be collecting. The EEO-1 is still there. And even if that, I'm not sure how long that will be there. There's a question about whether employers should still gather that data. There are other reasons to use that data potentially, right? For pay equity audit, or if there's a layoff and you want to do a disparate impact analysis. And I'm just gonna say, I'm gonna answer the question and say it's unclear right now whether employers should continue to gather that data. And in a lot of these areas, I mean, I was actually glad to see that 66% said they're sort of evaluating, because with a few exceptions, I actually think that's probably the best approach right now. And that's what I would suggest you all do with respect to information gathering. The other thing that this does quickly relative to federal contractors is it would have required them to certify. So, right, it would have prohibited federal contractors from engaging in, quote, illegal DEI, unquote, and it would have required them to certify that they don't do that in their contracts. Okay, you can go ahead. And what was really concerning about that piece for federal contractors is the False Claims Act, which is a statute that gives individuals the ability to bring fraud claims on behalf of the federal government and take a pretty significant piece of the recovery. And so that executive order was very intentional in having this certification in the contract, because that would have provided grounds for these False Claims Act claims. So you could have individual employees bringing claims if the employer was still engaging in DEI. It's unclear whether that was a legitimate threat or not. The good news for federal contractors, you can go to the next slide, is that piece has been enjoined. Just recently, February 21st, a federal judge in Maryland enjoined several of the provisions, including the piece that would have required certification. And the court observed the same thing that we have all observed, which is what is an unlawful DEI program. That's unclear. What does equity related mean? What does this mean that federal contractors have to certify that they're abandoning DEI related activities like altogether, or just that they're not using federal dollars for those programs? That's unclear. And then the other thing that the EO did was direct the agencies and the AG to sort of gather, a list of private employers who were potential enforcement targets, and that piece has been enjoined, but it's already been appealed. So again, there's just so much is uncertain, whether that will be back, how much, and in what form, totally unclear. The other EO that I think could have big implications for employers is this defending women from gender ideology, extremism, and restoring biological truth. And this really acts on the agencies and federal government and federal policy, but those are the agencies. The EEOC is the agency that it fills in the gaps, at least around employment discrimination regulation. And so this executive order declares that the federal policy is that there are only two biological sexes. Basically, gender identity is not recognized. Directs the agencies to revise their policies and change their guidance or their documents. Requires government issued identification documents, visas, et cetera, reflect biological sex at birth. And notably, maybe most notably, requires that single sex spaces be designated by biological sex. That's the policy that this EO is pressing. Also, you may recall, or you may not, this case, some people say Bostock, some people say Bostock, from 2020. Just remember that federal law, the terms gender identity and sexual orientation don't appear in federal anti-discrimination law. They've been a part of Maine law, protected characteristics in Maine, for a long time, but they still, to this day, are not protected characteristics in the statute, at least under federal law. And in 2020, the Supreme Court held that Title VII does protect employees from discrimination on the basis of sexual orientation and gender identity. And they held that those forms of discrimination are inherently discrimination on the basis of sex. Because, for example, a man, the employer is treating a man who is attracted to a man differently than a woman who is attracted to a man. I had a case a lot of years ago that this reasoning or analysis reminds me of. The employer had, there was a promotion decision at issue, and they passed over a woman with triplets in favor of a woman who had no children for this promotion. And the woman with triplets brought a sex discrimination claim. And we defended, saying, wait a minute, familial status is not a protected characteristic. Being a parent is not a protected characteristic. And a woman got the job. So how could you possibly show it was sex discrimination? And we were denied summary judgment, I think correctly, because the court said the question is whether you would have hired a man with triplets. Did she can prove perhaps that you would have hired a man with triplets, but didn't hire her because she was a woman with triplets. So it's a similar analysis here. But the Bostock case was a hiring decision, right? It was about disparate treatment discrimination, not hiring, not promoting. That's what that case really stands for. And what the EO is aimed at largely, in the employment context, is more the the impact that allowing transgender women to use women's restrooms or women's locker rooms, or framing that as actually sex discrimination against women. That's sort of and this case doesn't quite answer that question. I'll go ahead. So maybe I just said this, that basically the EEO is directing the DOJ to issue this new guidance, and the DOJ did do that and did say, did declare that the Supreme Court didn't mean to say that that discriminating against someone on the basis of gender identity means, preventing them from using the restroom of their choice, etc. And obviously, back to the civics lesson, the executive branch doesn't have the authority to tell the judicial branch what it meant. But this is kind of between the lines of that case. So the EEOC, right, one of the things you may remember that they issued just last year, an enforcement guidance on harassment in the workplace that goes into some detail around gender identity and sexual orientation, harassment on those bases. The executive order would direct the EEOC to essentially sort of modify that guidance or withdraw it. However, some changes to rules or policies require a majority vote, and the acting chair doesn't have that majority right now. So that is still out there. Again, that guidance is no more the law than the executive orders are the law. And I think the acting chairs made it very clear that a priority of the EEOC is protecting women's privacy. And so we can expect the EEOC to take the position that permitting a transgender woman to use the women's room or a locker room, if you will, is discrimination against women or harassment against women. I think we can expect that. I have increasingly sort of come to the conclusion that, especially when it comes to, locker rooms or bathrooms, regardless of your sex or gender identity, I think we all would like some privacy, and that transgender women, non-transgender women probably don't really want to be undressing in front of each other at work anyway. So I do think the solution to this, which I recognize is easier for some of you than others, is to try to implement as much privacy as possible so that you don't have to cross this bridge. But I do recognize that not everyone can construct a new locker room or construct, beautiful new bathrooms that have walls going all the way up.
We did have one question in terms of like, what are we doing now with EEOC in terms of the forms and collecting information and self-identification? Do you know if there's going to be changes to the forms? Are we expecting? I know we're currently using what we had.
It's hard. I don't know. I actually do expect, I expect that, in the coming months, there will actually be a majority, there will be appointments to the EEOC that will give the acting chair, the ability to do some of the things that she'd like to do, like rescind or modify this guidance. And I'm speculating, but I do anticipate that there'll be some changes to those forms. And I don't know whether they'll still exist or not, frankly. And if they don't, I don't know whether it will be lawful or not lawful. Like, that's the way that most of us get demographic data right now. I think it's really an open question. If that goes away, will it still be lawful for us to collect that data on a voluntary basis and a confidential basis in the same way that it has? So that's a stay tuned. This gender identity executive order runs right into Maine law in some ways, because as you all know, the Maine Human Rights Act does protect gender identity, and it used to be part of the definition of sexual orientation, which I always found very odd, but now it's its own protected characteristic. That doesn't necessarily answer the question of, I think that clearly means that, like the Supreme Court held in Bostock, employers cannot fire, decline to hire, decline to promote someone because of their sexual orientation or gender identity. It doesn't necessarily answer the question of whether an employer needs to allow a transgender woman, for example, to use the women's restroom. However, the Maine Human Rights Act is pretty explicit about that in the educational context, right? And we have a law court case that's a public school educational context case. So in some ways, the K through 12 schools and the public higher ed, they're really between a rock and a hard place because they have a Maine Human Rights Commission, they have a statute and a law court opinion that tell them what they need to do, and it conflicts directly with what the executive order says. I had long advised employers to assume that what's the rule in education is the rule in employment. And I can't do that anymore because it's not clear. And, I'm sure unless you live under a rock, you probably saw or heard about this sort of the confrontation between President Trump and Governor Mills, which drew some attention to the state of Maine and has might be more than 3 Title IX investigations at this point. So it's prompted some action. And so I'm not going to try on this webinar to answer the question of what should you do with a restroom situation if you are not in a position to create the kind of privacy that eliminates the entire issue. I think it's a really complicated question. And the answer might not be the same for every employer. So I'm sure somebody's going to put that in the chat. I would if I were listening. Switching gears a little bit, sort of moving into, or I guess following up on some of the DEI focus of the executive orders, or the anti-DEI focus. Just want to make you aware of a case that we will have a decision on very soon. Really, what those executive orders and the new policies are doing are sort of putting a spotlight on so-called reverse discrimination claims. And the Supreme Court just heard argument in exactly such a case where there's a split right now in the circuits where some circuits, including the Sixth Circuit, requiring non-minority plaintiffs. So for example, a straight Caucasian plaintiff to show something extra or additional than what a minority plaintiff would be required to show. So the Sixth Circuit dismissed. This woman was not hired, she claimed, or promoted. She claimed it was because she was not gay, and a gay individual was presumably hired. And the Sixth Circuit dismissed her claim and said that basically as a non-minority plaintiff, she had to show something more to prove that her employer was the unusual employer that would discriminate against the majority. I haven't listened to the oral argument, but I've read some analysis of it, and I wasn't surprised to read that the signals at oral argument were that the Supreme Court was going to overrule the Sixth Circuit and not require a different standard. That doesn't surprise me. And all that means is that, reverse discrimination claims will be judged on the same test will apply as other claims.
I was surprised when we did our little survey that this wasn't up. I mean, I think I was actually like second or third, so pretty high up, because if judging by the amount of questions that we get, this does seem to be top of mind for a lot of people.
Yeah, it is. And this is one too, where there's a lot that's sort of unclear. So, what the DEI means really different things for different employers. And I have worked with clients at all ends of the spectrum in terms of sort of how aggressive they are, what their policies or initiatives have been, et cetera. So it's hard to generalize, but I would say the law hasn't changed. It might, but it hasn't changed. It has been, and it is today, not lawful to use a protected characteristic as a basis for employment decision. It's not lawful, for example, to use race even as a tiebreaker for a hiring decision, or sex or sexual orientation, et cetera. And it has always been and remains not lawful to provide preferential treatment or additional resources, et cetera, to some groups of people, protected groups of people, and not other groups of people. So that's sort of a baseline, and that hasn't changed. That's not new advice, that quotas and things like that are not lawful. And in a couple slides, we'll talk about this a little bit more specifically. What I'm hearing assuming that all of your DEI programs do not contain quotas and other things that I think we've all known for a long time aren't lawful, that you're probably worried about the words that you're using. And, you know, the executive orders are very clear that, you know, scrapping the word diversity and inserting complexity or something like that, but without making changes to the underlying program, that's not going to fly. So, I mean, that's certainly true. If you are doing something that's over the line, changing the name isn't going to help. But if you are doing what I think is lawful, DEI, should you or do you need to change the name? I don't know. I mean, I think the reason to change the name is to draw less attention to oneself. That's the reason to do it. But ultimately, it's really the substance of what you're doing and not the label that matters. And changing the name, it could have the positive impact of drawing less sort of negative attention, but it could also draw negative attention from your workforce, right? Obviously, which may conclude that you're abandoning this as a priority. So here too, there's not a one size fits all answer. All right, so the practices that are unlawful or highly risky are, again, I talked about quotas, incentives, tiebreaker. When I already mentioned making resources available. So there are cases that challenge mentorship programs that are only available, for example, to BIPOC employees. Applying different policies or expectations to employees based on protected characteristics. That might seem obvious, but I have actually seen, I've actually counseled employers who were considering, having a different attendance policy for parents than non-parents and viewed that as sort of an equity strategy, right? That's not lawful. Parental leave, many of you have encountered this with parental leave, right? Providing maternity leave as opposed to paid maternity leave as opposed to parental. So those issues. The training that breaks people into groups and sort of, groups of privileged versus oppressed based on color of skin. I don't have a lot of clients that have been using that kind of training, but that's problematic. Employee resource groups or affinity groups that align with social identities. So, a BIPOC employee resource group, excluding others from that group. So having a group that's not open to allies, I think is pretty clearly in this unlawful or highly risky. Opening the groups obviously reduces that risk. And so what does that leave us with? Hopefully the kinds of things that you've already been doing. And hopefully it leaves us with what your DEI programs are right now, which is, broadening your recruiting base or thinking about how you go about recruiting with the hope of diversifying the candidate pool. Taking steps to minimize implicit bias until I see a law that says that's illegal. I believe that to be legal. I believe that to be appropriate. Appropriate on all ends, because implicit bias doesn't just exist against those protected characteristics. It exists. I can see implicit bias training actually furthering the president's policy in some ways at some places. Anti-harassment, respectful workplace training, obviously, affirmative action that benefits veterans and applicants with disabilities. I don't know that clients are actually are engaging in that, or at least in any aggressive way, but that's lawful. And the reason that's lawful, and in addition to the fact that that the executive order doesn't address those characteristics, the reason it's lawful is the statute. So Title VII protects race, and Caucasianness is a race. It also protects individuals with disabilities, not individuals without disabilities, or veterans, not non-veterans, right? So the other characteristics, race, sex, religion, they're just much broader and can give ground to a kind of a reverse discrimination claim, and those can't. And then again, what equity has become, I guess, a dirty word, but when we say equity, you know, usually what we mean is, you know, looking at policies, procedures, and the way we do things to make sure that they don't have an unintended disparate impact on anyone. Unintended and also just useless, right? I mean, if you're doing something that you don't need to do and it's having an effect that you don't want it to have, well, we need to fix that thing. I think that's still okay.
Along that lines, I think this is an interesting question. So companies who have parental leave policies, what do they do with those people who are not parents and need leave? So how do you mitigate those differences?
That's a really good question too. In some ways, in some ways, this is the only silver lining. Perhaps maybe there are lots of silver linings for parental leave, but I know it's really challenging for you all right now. But one of the silver linings is that it helps. It's going to help with that question. I have long sort of wondered. I've never seen a case where somebody who was a non-parent or somebody who had to care for their dying parent, for example, and didn't have leave available to them. But then here was a new parent that was getting paid leave, right? There is a bit of a value judgment there that employers are making, that new parents are somehow more worthy of support than other employees. And that cuts across sort of age to some extent, familial status to some extent. I've not seen a case challenging that, but I do see problems there with equity, if not maybe legally. And the paid family medical leave will probably help with that. It should.
Equalize that.
Mhm. So high level, again, I don't, you should not take away from this presentation that I think the words diversity and equity need to come off all of your websites and out of all of your policies. That's a choice that you need to make. I will say that inclusion and belonging are less lightning roddy right now. And if you're going to use diversity and equity, I do think it's important that if you don't already, that you define those terms really carefully, that your programs and policies do, so that it's clear that by diversity, you don't mean diversity of skin color or diversity of sexual orientation. You mean diversity of experience, viewpoint, perspective. And obviously those things align sometimes with diversity of skin color or sexual orientation. But what you're aiming for, it is the diversity of experience, viewpoint, and expression that's valuable in the workplace. It's not just the fact that people have different color skin, for example. So sort of say what you mean and just be really intentional about it. And you're already probably all reviewing your policies and web pages, and just, you know, think about language, make whatever tweaks. If something is over the line, now's the time to fix it. I do think it's important that organizations are really careful that employees and stakeholders are not speaking out about this topic publicly when they're not authorized to do so, and are not doing so in a way that's actually consistent with the law and consistent with your programming. That is important. And then finally, the employee relations implications of this, that those are, you know, those are real, and those you know, you need to weigh those against the changes that you're making, and communicating about it. Just pulling everything off the website is likely to lead to a lot of, you know, questioning and drama and concerns about whether you're abandoning these principles.
We got a flurry of DEI questions, so just so people know I'm not ignoring you, we'll come back to them.
Okay.
Hopefully if we have some time in the end.
Okay. I'm going to say very little about Maine paid family and medical leave, because there are lots of other webinars that you've probably gone to that really get into the weeds. The things to know, if you don't already, obviously April 1st, the deadline for applying for a fully insured or self-insured private plan is rapidly approaching. And also you may or may not know that there is litigation pending right now that challenges the absence of any refund for those employers who are paying. You're all paying in, but for those employers that end up being approved for a private plan. So there may or may not be a change there. There's also legislation, I think a couple of bills to repeal the whole thing and refund all contributions. I don't have a lot of, I don't think that's likely to happen, but who knows? And then there's also another bill pending that would eliminate the provision in the law that requires employees to schedule leave in a way that doesn't prevent an undue hardship. And I'm hopeful that that also isn't successful. Okay, the rest is a bit of a hodgepodge, I think. We'll jump around a little bit. And so with the kind of, back to with a new administration, policies and the views of the agencies change, this is likely to be one of those examples. So the Pregnant Workers Fairness Act is relatively new statute, a couple of years maybe, that expressly requires employers to accommodate pregnancy-related conditions. And the EEOC's implementation guidance document on that statute makes it clear that pregnancy-related conditions, or at least that EEOC thought pregnancy-related conditions was very broad, very, very broad, to include fertility treatments and also to include pregnancy termination, abortion. There's a lawsuit pending, and that the 8th Circuit recently found that the states as employers have standing there. Again, once there's a majority of similarly minded EEOC commissioners, I suspect we'll see changes to the underlying guidance, which may end up kind of mooting the statute, but that's just sort of an interesting tidbit. So some of what this, the program is entitled Times of Change, and the Times of Change includes both things that are new and things that were and are no longer. And so a few of these will be in that second category. As you all know, I'm sure, the US Department of Labor enacted a rule that would have increased the minimum salary significantly. And that was enjoined by a Texas judge at the end of last year. I know this is not news to you. So that's unlikely to be revived at this point. And it is possible that the Trump administration would support a more modest salary increase. The Maine salary increase is presently higher, so it would have to increase kind of significantly, I think, to change things in Maine, but something to know. So it feels unhelpful just to say something about exemptions or minimum salary thresholds without doing a plug or a reminder around what you all really ought to be thinking about in this area. Wage and hour claims, especially when they are of a nature that lend themselves to class action treatment. So there's a large group of employees that are subjected to the same issue, can be extraordinarily expensive. The statute of limitations in Maine is 6 years. So we go very far back. And there can be, a significant number of individuals in that class over that period. And then in addition to their back wages that they're due, there's liquidated damages and attorney's fees. So it's just really this decision around which employees are exempt from overtime and which are not is a really important one and worth your attention. I continue to see clients who are overusing the administrative exemption and applying it to any sort of white collar back office sort of role. I also see people treat as exempt anyone who does extremely important work. And it's just not the case that exempt equals important work, right? There are very specific duties set forth in the statute and the regs, and it's those matter. The other piece is that pay transparency is coming. Yeah, I'll say that. We'll go to this one then. By pay transparency, I mean statutes that are sort of sweeping the nation that require employers to include pay ranges or pay with job postings, or to provide those to employees, or and that I feel like we've seen one of these pending for the last several legislative sessions, and it's back. And so this statute would require employers with 10 or more employees to post the prospective pay range that the employer will offer in any job posting, to disclose the actual pay range of a position held by an employee who asks you for it, and to maintain certain records. And this is this will pass at some point. I don't know whether this is the year or not. But I do think there's no reason to not start preparing yourself for this. It's going to, if you're not prepared for this, and if you haven't been undertaking sort of pay equity audits and really ensuring that your ranges make sense and that there aren't disparities based on protected characteristics, this statute is going to generate a ton of litigation for you, because your employees may already be talking about pay, and that's one thing, but publishing it on Indeed or wherever is another. So this is something to get ready for in your spare time. Just a word about non-competes. You probably will remember that last year, the Federal Trade Commission, there was a proposed rule that would have effectively banned non-competition agreements extraordinarily broadly. That rule was enjoined. That injunction was appealed, but it's pretty clear based on the new makeup of the FTC and the anticipated makeup that appeal is almost certainly going to be abandoned. We also had, it's been a couple of years, I guess, since the NLRB's general counsel, who was fired recently, issued a policy statement to the effect that non-competes violate the National Labor Relations Act. And the theory is that if an employee, that it chills protected speech, because if an employee can't go to another employer, then they are, basically stifled in their ability to speak out because they're sort of handcuffed to their current employer. I'm not sure why the well, I'm not sure why Section 7 doesn't take care of that. If they're fired for their protected speech, they have a claim, but that was the general counsel's position. That'll almost certainly swing as well as NLRB stuff does.
Katie, we use the term enjoined a lot, but do you mind just explaining?
What that means? Yeah. Enjoined is the verb for injunction. An injunction is an order, that a halt, just to stop, like a pause, a no. It's sort of like it's stayed. And so where the court, usually that happens really early in a case, and what the court is saying is we think the plaintiff is likely enough to win, and the harm that will be caused if this thing happens is really irreparable. So we're just going to stop it while the litigation continues. That usually is the end of the matter. The injunction usually ends up ending the case. This is also not new guidance, but I guess worth emphasizing. I have long advised clients, long before non-competes became, the subject of legislation in practically every state, that they are not a one-size-fits-all tool. They should be used selectively, and they should be used when other agreements, like non-solicitation agreements, meaning an agreement that would prevent an employee from soliciting employees to come join them, or soliciting your clients or your customers, or your vendors, depending on the nature of your business. A non-solicit and a confidentiality agreement will often be sufficient to protect your interests. So non-competes will never be enforceable they are not enforceable if the interest you're trying to protect is just preventing competition. Everybody wants to prevent competition, and that's not a legitimate business interest. There has to be something special that this employee could do, some way that they could harm you in particular because they worked for you and are now competing, and just be thoughtful about that. And just remember as well, in Maine, non-competes aren't enforceable. We have a statute now, so they're not enforceable for 1 year after hire or 6 months after they're signed, whichever's later. So it's not possible to get a non-compete effective immediately, in Maine. And in some states, they're not enforceable at all. We are gonna wrap up with immigration related discussion, and a caveat that I am not, my immigration expertise is relatively limited. But a couple of areas where we're gonna see changes with the new administration. If you have employment-based visas like H-1B workers, you can expect increased sort of scrutiny of whether you're complying with those rules. So, right, there are rules around H-1B, and these kinds of rules apply, I think, in other visa-related contexts too. I'm just using H-1B as an example. You're required to pay the employee certain wages. You are there's a requirement that the person is actually working where they say, you indicate that they're working on their paperwork. I've heard a lot about increased inspections to make sure that workers are actually working at the work sites where they say they are. I think we'll also see, well, I-9s, I shouldn't have skipped that. I mean, clearly I-9 compliance has never been more important. And so if you have not done an I-9 audit in a while, now is the time to do that for sure. I've read that we're likely to see employment-based immigration slow down for a few reasons. They may revise the H-1B program to make it more selective. Right, because the concern of this administration is that there are US citizens who could do some of these jobs and are being passed over for the jobs in favor of the expensive process of sponsoring an employee from another country. So I think you can expect that to be more challenging. I've read that they are going to slow down, they're going to slow down sort of processing. So there may just be an administrative sort of logjam. We'll talk about raids in a minute. We may see travel bans again. And then there are some statuses that are currently support work authorization right now. And so you may have these workers, and those statuses may be in jeopardy. So this is a subject to stay close to. And with questions, contact immigration lawyer. A lot of my clients are really scared about, or their employees are really scared about site visits and raids. I have seen a lot of employees putting pressure on the employer to give them some guidance or advice about this. And obviously you have to be thoughtful about the advice that you provide and whether you're providing advice, like whether you're providing legal advice to individual employees or whether you're providing them with advice because it's in the company's interests. And so what I'm going to share is really company related advice or company related messaging that you could give employees that protects the interests of the company. It's not educating employees about their individual rights, if you will. These principles apply not just to ICE coming to the workplace. They apply to OSHA or any other regulator, Department of Labor. It is important to have some kind of a plan for what's going to happen if somebody shows up at your door, and we'll talk about it as ICE for the next few minutes. You have to think through sort of the physical layout of your space or your offices and where is that person going to go. And obviously if you have a reception area, that's more straightforward. I know not all of your workplaces are that straightforward. So there may be individuals who are designated in different spaces. But those individuals really need to be educated and trained around what to do, to be not to freak out, to be greet them and be polite, not to answer their questions. We'll talk about a potential script in a minute, but they ought to have a script. And it's going to involve them, you know, calling counsel or calling whoever within the organization is prepared to do, do the things like ask for the person's name and ID and whatever paperwork they have and that sort of thing. Let's see, preparing the work site. So you want to know that person is hopefully going to take the regulator, the ICE enforcement officer to a particular space. They theoretically cannot go, or legally cannot go wandering into private spaces without a warrant or consent. And so, but if somebody's walking them through certain workplaces, you could see that they could gather a lot of information about private areas without crossing there. So, whether it's easy to sort of demarcate private and public areas in your workplace, I'm sure for some of you it is, for others it isn't. This is just something to be mindful of. We want to limit what the agents see without a warrant or consent. And I think the last point, consider in advance, if there is an individual employee who's caught up in an enforcement action or is detained, or they may look to the employer for representation or guidance. It's not uncommon that the business immigration lawyers, they represent the employer, but they also have a relationship with the individual employee. And so this can get gray. And I just encourage you to be thoughtful in advance around if this is a risk in your workplace and you have workers who are in sort of a risky status, consider in advance the extent to which you, the company, are prepared to offer them counsel. And the last two slides are really a couple of sort of sample scripts. I said it was important to have a script. These were actually written up. I have heard people recommend that you take a script, whatever your script is, and actually print it on something like a card so that whoever it is, and I'm going to use reception, again, recognizing that not all of you have receptionists sitting out front, but that receptionist can look at the card, and because they're going to be scared, it's going to be scary and it's going to be hard for them to think. And this is the kind of information that this is the messaging that we want them to provide. If you have a seat, if you think you have grounds to search the premises without a warrant, let me know. And that should say what the grounds are, not the groups, what the grounds are, so I can make note of it for our council. And I'm not allowed to let you into non-public areas. And it's really a statement that the company is not permitting employees to be interviewed about company matters. And the company doesn't allow employees to consent to warrantless searches. If you flip to the second script, it's very similar, and you'll have these materials. It's a directive from the company that you are not to participate in an interview and speak on behalf of the company. One thing that needs to be part of the training, and I do see it here, for reasons of safety, employees have been instructed not to physically impede. Really important for employees to know. I would like to think that any regulator, including ICE, would not insist on going into private areas without a warrant or consent. However, who knows? And if that ever were to happen, the last thing we want are employees to actually physically block them or get into any kind of a verbal or physical confrontation with them. So we should not be sort of instructing employees that it's their duty to protect the company's rights or their coworkers' civil rights. I don't think I could have gone. Oh, do's and don'ts. We had one more. Okay, good. I was trying to weave those in because I didn't see them in my packet. So yeah, do refer to the script, be polite, stay calm, call counsel. Don't do all the things that I already said you shouldn't do. And I came up about as close to 1 o'clock as one could.
Yes, that was great, Katie. Thank you so much. So we do have a minute if people have additional questions, or like I said, we got a couple of DEI questions if we wanted to try to answer those.
Right.
So if you have to jump off, go ahead. Thank you so much for joining us on this presentation, and thank you again to Katie. And yeah, so just really quickly, so there was a question in navigating job qualifications on a job description. If there's a specific need for a candidate to speak another language other than
Mhm.
English,
Mhm.
because they're working with a specific community,
Mhm.
they've been advised to remove the language preference from the job posting.
Oh, but the job is to communicate with a specific group?
Yeah,
Well, okay, so with the caveat that I'm not providing legal advice and that I couldn't anyway, all right, I couldn't even actually advise here without without knowing a lot more. I will say that there are times where things that align with a protected characteristic are essentially like a BFOQ. And another context where I see this is like peer supports, like there are certain, right, behavioral health or, you know, community agencies where having had experience with addiction, for example, is a part of the job, right? You maybe have another conversation about that to see whether maybe that is appropriate.
yeah. One more, and then if people are interested, I'll slide back to the results from the survey. There was a question about training, DEI training, that,
Mhm.
you know, companies, organizations have been encouraged to include those trainings. They're in the process of revamping programs, training programs. Should they have DEI training? And I guess without knowing exactly what the training is, that might be hard.
Yeah, it depends. I would say it depends on what it is. I do think, well, certainly, I mean, harassment training or like sort of
Right.
respectful workplace training, right? That stuff's not only still okay, it's probably required. That is different from training that focuses on certain protected groups like racial equity training. Right? I think that is less safe right now to have a specific protected group focused training.
All right, y'all, hang tight. I'm gonna slide back up. We can look at that survey results really quickly together. So we had 80 response. You can still respond to it if you want. Whatever is the final result is what I'll include in your slides that will be shared with you. But yeah, I mean, Maine paid family leave, #1, wage and hour updates, DEI changes, EOC.
Maine paid family leave is gonna change 2026 like nobody can prepare for. So many more employees will be will be on leave starting in 2026, no question.
We stayed right here, so in this evaluation mode. So hopefully, I'm hoping people walked away feeling more prepared and but like Katie's saying, like some of these things we're just gonna have to continue to evaluate. But like I said, I'll happily share these once they're fully populated. If people are still filling them out, you still can. They're still open. Thank you everybody for joining us today. Thank you so much, Katie. This was incredibly helpful and informative, and we really appreciate you.
Happy to do it. Good to see you, everyone.
Thank you.